There we go. All right. Well, let's get started then. All right. Well, good morning, everybody. Thanks for joining us. I appreciate your tuning in via Zoom rather than having to drive in this fun February weather that we're having or have had overnight. So this worked out really well. Thank you to Kim for accommodating us and doing it in this fashion, and it's a little bit safer for everybody. I just want to do a brief introduction of Kim, and then I will turn it over to her. Kim Harding is a partner attorney in Nixon Peabody's Labor and Employment Group, the deputy leader of the litigation department, and the leader in the firm's labor relations team. Kim's experience as a manager of Nixon Peabody's own team of litigation attorneys informs the counsel she provides her clients and gives her unique insight into the challenges they face in managing their own workforces. We're very happy to have her again here this year. She was here last year and provides some really great insight and information on what is happening in the labor and employment world this year and coming up. And so I'm going to turn it over to Kim, and then if you want to just remind everybody, if at the end we can have time for questions, you can type them in and we can manage that, and then you can change your view to speaker view if you want to just watch her instead of looking at the I don't know what we call this view, but at the everybody view we'll call it.
Thanks, Scott. Thanks everybody for joining us. It's nice to see some familiar names here. I told Scott I don't have slides because I just assume you'd all rather look at my face. Just kidding. But hopefully this will go quickly. And feel free to ask questions, interrupt me at any time. There's a lot of content here, but we will move through it quickly. So hopefully this will be as painless as possible when we're talking about more and more regulations from our state and federal governments. And I should say this is perfectly timed because I did this a similar presentation for another group at the beginning of the month. And since the beginning of the month, we've had more developments. So you guys are getting the latest and greatest, including something hot off the press from 2 days ago. So I wish I could tell you it was good news. It's not, it's just not. Okay, so without further ado, I'm going to start with something pretty easy, pretty basic. We continue to see increases at the state level for the salary basis and the minimum wage requirements. For us, the minimum wage as of December 31st has gone up to $14.20 per hour. We're the only area of the state that is below $15 an hour. So if you have other locations in the New York City, Long Island, Westchester area, they're already at $15. The state says that they're indexing the increases to the minimum wage with inflation. That's basically just like a cover to say that they're going to move us to $15 an hour, but more slowly. So, I mean, I guess if inflation goes way down, maybe we can put that to the test, but I wouldn't hold my breath that we're not going to eventually get to $15 an hour. $14.20 right now, though. So that's the takeaway there. If you have individuals employed as exempt employees under the executive or administrative exemptions under the New York labor law or the Fair Labor Standards Act, those employees have to be paid now a minimum of $1,064.25 per week. So that's up from $990 per week. As a reminder, to classify employees as exempt from overtime or minimum wage regulations, they have to be paid that flat salary. Can't change, it has to be the same every week. And then they also have to meet the duties requirements of either the executive or the administrative exemption to qualify for that. So want to make sure that we're properly paying overtime or making sure that we satisfy those requirements to exempt folks. The professional exemption doesn't have a state basis, or excuse me, a state salary basis. They remain at $684 per week, which is the federal minimum. So most of our teams probably don't have too many people classified under the professional exemption, so it's not worth spending a lot of time on. The one to focus on is the executive and administrative the executive and administrative exemptions. Those folks need to be paid $1,064.25 per week. Okay, pay transparency is the next, right? I guess the first hot ticket item we can talk about today. As of December 2022, New York City implemented a pay transparency requirement. Coming up in September, September 17th, that's going to go into effect statewide. So if you have 4 or more employees, that means you'll be required to post the compensation or range of compensation for all job promotion and transfer opportunities. And that's the minimum and the maximum that the position pays. So it's easy, right? If this is a minimum, well, it's not easy. It's easy if it's a minimum wage position, you just put $14.20 per hour, that's what we're paying. But if there's a range that you would pay, you need to put the minimum and the maximum, and it needs to be a good faith estimate of what that looks like. So if you would pay a lot more for an employee with experience, then we may want to think about breaking out job postings into, quality assurance tech 1 and quality assurance tech 2, so that we can better align the compensation ranges with what we would pay. Because if we put like, oh, we'll pay $30,000 to $90,000, the state's going to say that's not a good faith estimate. That doesn't tell anybody anything. So you want to be careful with that. As a reminder, that's internal and external postings. So that's if you have an internal transfer or you're posting something internally, we still need to include that. It's not just advertisements, it's any job posting. In addition, we need to be including the job description for the position if it exists. Good opportunity to look at our job descriptions, make sure they're up to date, make sure that we have all the essential functions of the position listed, and then also include a general description of other forms of compensation that would be offered. So this is your benefits package, your fringe benefits, any bonuses or commissions, stock options, things like that. Anything you offer needs to be included in that job posting. This applies to any position that can be performed in New York. So if you're, if it could be performed remotely in New York, needs to follow these requirements. And that's important to think about. So if all the people on site, as well as anyone who could be performing it anywhere remotely in New York. Like I said, this is a good faith estimate. So really thinking through how you can break that out to get as close as possible or be as reasonable as possible with our estimates will go a long way. Moving on, I have called this, I said that this will be, this is it's a banner year for New York State, or really it's a poster year, because like 90% of what I'm going to tell you about are just like random posting requirements that we have. I don't know how much wall space they think we have, but apparently they think we have a lot because we have to post a million things. The first thing here is there's a new EEOC poster. So presumably a lot of you have walls in your break rooms or somewhere where you have a million postings. We need to take down the EEOC poster as it exists and put up the new EEOC poster. It's just refreshed, updated. Maybe they got a new graphics designer. I don't really know. They're really excited about it. Let's make sure that we have that updated. That's got to be placed in a conspicuous place. And at the federal level, they encourage you to also post it online or on your internal website. That said, the supplement here, if you do post it online, that is not a substitute for the conspicuous posting. We do need a physical posting in addition to the online posting. And as I'm going to tell you in just a second, you're going to see in New York State, as of this year, we need to post everything online. So again, we still must post in the physical physical place. But as of December of last year, we're also required for New York State to make all state and federal postings available on our websites, meaning the internal website, or we have to distribute them via email. So we also need to provide a notice that they're available electronically. So if you have a handbook or something like that, you'd want to add a detail that says, as a reminder, all of the required postings were sent to you by email when you started, or they're all available on, like we call it NP Connect is our internal site, whatever it is, whatever folks have access to, that's where we need to be posting stuff. And again, that's a requirement in New York State. Does not replace the physical posting requirement, but in addition, we also have to distribute every posting electronically. We'll mention that the state actually has a helpful, I hate to call anything that the state does helpful, but they do have a website that includes all of their required posters. If you just Google like New York State required posters, I used it like 25 times making this presentation. So there's just a list, there's PDF printouts, and you can kind of see what you need, at least from the state level. For those of you with 50 or more employees, don't forget that you also need to include the new veteran benefits and services poster. That requirement went into effect as of January of this year. On the topic of notice, we also want to make sure that we're including paid family leave notices or paid family policies. Those need to be amended this year to make sure we're including the available leave to care for siblings. As of January of this year, the update to the statute that says that PFL is now available for sibling care went into effect. So we want to, again, just make sure we update our handbooks. Our insurers should probably be on top of that. That is, if you know me at all, one change that I would be excited about. So that like maybe my brother can take care of me one day, but yes, in any event, we just want to make sure that we're aware of that change. That's been coming for a while, but it is now effective. Moving on to whistleblower protections. As a reminder, last year, the state expanded the protections for whistleblowers to go from like a very, very narrow set of claims. Had to be like someone complaining about something that was a threat to the general public safety. That has been expanded tremendously to protect anyone who makes a complaint about an unlawful policy or practice, that anyone who has a reasonable belief about a violation of any law, rule, or regulation. So before, it had to be an actual violation and it had to be a substantial danger to the public health or safety. Now it's if you have a reasonable belief that any law or policy or law, rule, or regulation has been violated, they have protections for making those complaints both internally and externally. So we want to be very careful that we're aware of those protections and that we're not taking adverse action against employees on that basis. Similarly, another notice requirement that went into effect last year, as of May of last year, was the electronic monitoring notice. If you ever dig into employee emails or have any ability to kind of review them, or you monitor phone calls or anything like that, the state says we need to notify and obtain acknowledgement from new hires about this. So there's specific language saying that we reserve the right to monitor or intercept all of these types of communications. That's email, phone, or internet access or usage. This policy we suggest goes in the handbook so that people are aware of it. And then it just becomes part of your onboarding process as new hires kind of come in. When they sign the acknowledgement, we would include a little thing that says, this also includes our electronic monitoring notice, so that you kind of don't have a new form that you have to keep. But again, we need to make sure that all new hires are signing off on that. I will say, even though the notice and the acknowledgement piece is a pain, this is something that we do want to make sure, just from a legal perspective, that we protect ourselves. If you've got good lawyers, they should have updated your handbooks to include something like this already. If you don't, call me. We'll update it and make sure that it's in there. But this really, particularly in litigation, gives us a lot more leeway and license to review a lot more employee emails than we might otherwise have, particularly when employees are foolish enough to email their own attorneys on company email, which happens way more than you would think. But it destroys the privilege in those instances. So we kind of get access to all of those communications. It's a really good update to include and benefits us more than we otherwise might think. Moving on to lactation requirements, which got a lot of updates this year, but are kind of a nothing burger. So we'll kind of run through them. So at the state level, we do have some changes. So in New York, we were already required to provide reasonable break times for expressing breast milk, or to allow employees to use their break periods for the expression of breast milk up to 3 years following the birth of their children. We also had to provide a room or a location to express that milk in private. They kind of estimated this would be about 20 minutes every 3 hours, but it kind of give or take based on the particular situation. These requirements are still in place. They've just kind of gotten a little bit more specific. So now the state is requiring that we make sure that the lactation room is in close proximity to the employee's particular work area. So it's going to be person specific. Is it close enough to their workspace? It needs to be a well-lit room, shielded from view. and free from intrusion. Cannot be a bathroom or toilet stall. Again, this is one I can support. From here though, there's more. There's more. We also need to include a chair, a work surface, nearby access to clean running water, and an electrical outlet. In addition, if there's refrigeration available on site, we have to allow women access to that refrigeration to store the breast milk. This room, the lactation room, can be used for other purposes. So you know, it can be maybe it's a break room space, maybe it's a wellness room. I don't know what else, why would we just have a random room sitting around? What would that be used for? It can be used for other purposes. But if we have a breastfeeding mother, we have to give priority to that. So she has to be able to use it and kind of kick everyone else out, and give that priority to lactation. I'm probably not going to be surprised here, given the theme so far, that there's also a notice requirement affiliated with the lactation, new lactation requirements. So we need to notify all employees when a room has been designated. So if you have a woman who's returning from a childbirth leave, and you said, okay, well, this is going to be Kim's lactation room or the lactation room for whatever, because sometimes it's temporary, right? We have to say, maybe not that it's Kim's lactation room, although the writing's probably on the wall. But to say, you know, just FYI, everybody, room 302 has been reserved. It's the lactation room. Please be respectful and, you know, try to honor that. And in addition, we need to distribute our policy on lactation. Again, it can be in the handbook. That has to go to all new hires. And when women are returning following a childbirth, they also have to get a copy of the lactation policy so that they understand their rights. And again, it would probably be helpful if we told them where the lactation room was when they came back, like otherwise, what's the point? So I assume you're probably doing this already, but just want to include that. Okay, my computer just told me it's about to restart, so let's put that on pause. That would be bad. If I disappear, it's because my computer restarted itself. I'll be right back. Okay. At the federal level, there were also a number of acts that were passed last year. But from a New York perspective, they didn't really change anything. New York was already more stringent than the federal requirements. So for instance, the PUMP Act expanded the FLSA's protections to allow break time for breastfeeding to exempt employees as well as non-exempt employees. Again, in New York, this was already the case. I do think it's funny that this PUMP Act is officially called the Providing Urgent Maternal Protections for Nursing Mothers Act. And I just want to know who names these statutes, like who gets that job, because you're like, you know what, PUMP would be a good acronym. And then you just come up with words that fit that. But so I don't know. Anyway, if you can't find me at this job one day, it's because I moved to DC to be the statute namer. So I think we could really do a better job on that, but I digress. Okay, there was also the Pregnant Workers Fairness Act. And this requires that employers provide reasonable accommodations for limitations related to pregnancy, childbirth, or other related medical conditions. Again, in New York, we were pretty much already doing this, and really under the ADA and the Pregnancy Discrimination Act, this was already pretty clearly required. But they just kind of clarified this. The big takeaway here is that we cannot require leave of absence if other accommodations are available. So for instance, if a pregnant employee needs more break time to use the restroom or to drink water or something, or needs a stool, we can't say, no, you know what, we can't do that. Instead, you should take a leave of absence and you'll just be out. We have to provide the accommodation if it's available and can't immediately move to a leave of absence unless the employee requests it. Okay, that's it on lactation and nursing mothers. We now get to move on to protections for protected absences, which again is at the state level. I'm sure you won't be surprised to hear that. But as of this week, this went into effect where the state now prohibits any assignment of points or occurrences or anything under a no-fault attendance policy for leaves that are protected. So this is if an employee uses paid family leave or New York State paid sick leave, FMLA, things of that nature. we can't assign any points under our policy. Kind of, I think previously the point really of no fault attendance policies is really just so we don't even have to ask. If we don't want to know why you're out, we're just going to give you a certain number of points. We're not going to get into the reason. We just kind of say you need to show up and you get this many absences. And they would kind of bake in the paid sick leave and paid family leave types of absences. Here, the state is being abundantly clear that we cannot assign points for those absences. So we need to make sure that we're inquiring with employees to kind of ask for the reason for the absence or ask whether they're using certain types of protected leaves. Are they out for jury duty? Are they taking a COVID leave? Those types of things. This is a pretty big deal, mostly because the state has caught on to the fact that a lot of their prohibitions don't really have any teeth. And here they put some teeth on it. So this is a $10,000 penalty for a first violation and $20,000 for each subsequent violation. So this could add up pretty quickly. We want to make sure that we're being careful, particularly, and I know we've got a lot of HR teams on here, and this really puts the pressure on us to make sure that we're getting things right and not assigning those points, because again, the assignment of that 1 point can cost us $10,000, and not really what we are hoping for. In practice, I do think this is probably not a huge change. We're probably already carving out these types of absences like paid sick leave, FMLA, those types of things. And I also just want to point out that this is just related to disciplinary policies or unpaid time. So if you have a PTO policy, right, and you say, oh, you can use 40 hours of PTO for X, Y, and Z reasons, you can still deduct the hours from the bank. So if you have a sick leave bank, still deduct the hours. We just can't assign a disciplinary action to that. Or if they run out, if you have a general PTO policy that includes sick, vacation, et cetera, if they're using a paid sick leave day, we can deduct from the bank, but we can't, we may have to offer additional unpaid time or something like that, or can't discipline if they're using protected leave. Hopefully that makes sense. Yes, okay. Couple more things here. We're really kind of cruising through it. New York State COVID pay. We get a lot of questions on this, and like the spoiler alert is this is never ending. We are going to live with this for the rest of time. This was enacted by statute, meaning that the legislature passed it and they neglected to put a sunset date in here. I wish they had, because that would mean COVID might ever be over, but they apparently had the foresight that it was never ending. So in any event, there's no sunset date here. The federal statute, as you know, did have a sunset date. That is gone, but the New York State COVID pay, unless the legislature gets together and says we're going to take away a benefit from employees, and like, don't hold your breath for that happening, this is going to be around till the rest of time. The good news is that the limit on this is 3 times in the employee's lifetime with an employer. So there's been a lot of confusion. A lot of my clients think that they get to use it 3 times per year. That is inaccurate. It is 3 times ever at your employment site. So that should put some limitations around it, at least I hope, or it should provide some relief. At least until the state changes its mind and tells us there's a different limit. But right now it's 3 times. And that, again, this is something that's not going away. What is going away is New York State vaccination pay. This is the up to 4 hours for every vaccination shot. That will end on December 31st of this year. So that's some good news. I think the number of vaccination requests has probably waned significantly. So this is probably not going to be a huge economic benefit, but at least it's one less thing that we have to keep track of or worry about. Enough about COVID. Let's move on to non-competes. The FTC proposed a prohibition on non-competes that would ban them nationwide for workers of all industries. And require that all employers rescind their existing non-competes. This also would carry a penalty of $10,000 per violation. It didn't propose to prohibit non-solicitation or non-disclosure clauses. unless they were kind of couched as non-competes in disguise, like they were so broad that they would actually effectively be a non-compete. But there are other stringent requirements, including that notice of rescission means employers would have to provide an individualized communication to each employee who had signed a non-compete within 45 days of the rule becoming effective. That's the rub. So when will this rule become effective? And the answer is probably never. This is a little bit of smoke and mirrors, I think. I don't want to jinx it. But just for context, the notice of the proposed rulemaking was issued on January 5th of this year. And then it is by law required to have a 60-day comment period. So that puts us like in March, early March. And then the FTC has to take all the comments, digest them, or at least pretend to read them to come out with the final rule. We anticipate that would take at least 6 months unless they're working really expeditiously. Government workers not actually known for that, so stay tuned. So anyway, picture at least 6 months, and then the rule becomes effective 180 days after it's published, so another 6 months. So in other words, we're looking at least next year before the rule would even be proposed to be effective. And then it's going to almost certainly be challenged. It will be challenged probably like the minute that it's issued, probably somewhere in Texas, which is usually where we see these things challenged. But this will be similar to the salary basis requirements that the Obama administration had proposed. We literally just got a Supreme Court decision on those yesterday about whether this salary basis kind of could be used. And again, didn't change much, but that was what, 7-8 years, maybe more of litigation. And by the time anything happened, we had a change of administration and they were rescinded anyway. So I anticipate that will probably be the case here. It's not something that at this point, I wouldn't spend a lot of time reviewing your non-competes. I don't think that's a good use of time. Next year, when I come back, I'll let you know if there's anything to do, but that's probably a better time to worry about it. Okay, finally, our last topic today is labor activity. And then I'll get to your questions as well. I feel like I'm talking a mile a minute here. I had Starbucks this morning, so bear with me. So the National Labor Relations Board describes itself as the most employee-friendly board in American history. The Biden board is extremely progressive. The decisions we are seeing like barely comport with reality, let alone the law, but this is what we're stuck with. And that is creating a lot of issues for employers. This is both union-free and unionized employers, which is important to remember. Even employers that don't have unions or are not subject to collective bargaining agreements still have obligations under the National Labor Relations Act, and their employees are protected by Section 7. This dynamic is just one of a number of factors that are contributing to kind of this like wave of employee empowerment that we're seeing. So it's this extremely labor-friendly board that is like heavily advocating for employee rights. That is coupled with the Great Resignation, the worker empowerment and dissatisfaction that we saw all throughout COVID, that some of the dynamics kind of have shifted as we're losing people or people are shifting around, asking for more in their incoming negotiations. And then we see a lot at the federal level. There's a lot of prominent politicians who are effectively using social media to glorify unions and protected concerted activity. That is leading to a number of organizing drives like we see with Starbucks and Chipotle. Those hit the news, employees see that. Then this is like a boulder rolling downhill, picking up, I'm terrible with analogies, picking up steam. Momentum, I don't know, bear with me. So anyway, all of this is contributing to what I think is one of the most challenging labor environments that we're seeing. And it's also contributing to, we're at like a 57-year high with the popularity of unions or labor activity generally. We are seeing more organizing activity than we've seen in decades. I'm just seeing a lot of very busy labor lawyers, myself included, and a lot of activity out of the NLRB. So, like I said, obviously, if you have a union, you're probably familiar with this, or kind of the constructs. If we don't have a union, what's really important is that we do our best to make sure that we don't end up with a union. And the best ways to do that are to be engaging your employees, making sure that you're reviewing your handbooks so that you don't end up with a Section 7 violation, because the penalty for a non-compliant handbook under Section 7 is you have to post a notice and say, sorry, we messed up. Not really a big deal, except if you have a union election going on and you have an unlawful policy. If you win that election, then the board will say, no, oh, sorry, you had this unlawful policy. You have to do the whole thing again. So that's a pretty big deal. And we just want to make sure that we're being very proactive, taking all of the defensive courses of action that we can, so that we're prepared if a union kind of comes in or starts any organizing activity. Because once that happens, it happens quickly. And we don't have time at that point to kind of be reviewing policies and making sure we're compliant. We want to do everything that we can on the front end. We also want to make sure that we're identifying our supervisors. Who can we rely on in a union organizing campaign? Who would be part of the bargaining unit? Who would not be part of the bargaining unit? And who should we be training to look for signs of union organization? We do union avoidance training pretty regularly on my team, and we're training supervisors to say, these are things to look out for. This is what you can and cannot do in a union organizing campaign, and we want to be very careful of that. Again, this is all kind of a genesis of a very friendly National Labor Relations Board, where we're seeing a lot of reversals on decisions, which is honestly part and parcel of the way the NLRB works, right? It's a politically appointed board. It's usually 3 members of the party in power, and then 2 members of the non-party in power, party and non-power, 3 and 2. So it's currently 3 Democrats and 2 Republicans. Under the Trump board, it was obviously the inverse, but you see this cycle of every 4 or 8 years, the new administration kind of undoes what the previous administration does. And it's always this little back and forth. And we need to take into consideration the political headwinds that are happening. Because again, that pendulum can swing back and forth. Right now, it is swinging further back than kind of anything we've seen in a while. And that includes a recent decision this week. So this week, the National Labor Relations Board said that in severance agreements, it is a violation of employees' Section 7 rights to include a non-disparagement clause and or a confidentiality clause. So if you say, like, as part of this settlement, you can't disparage the employer, the board says that interferes with employees' rights to engage in protected concerted activity. And it similarly says that if you include a confidentiality clause saying that you can't talk about the terms and conditions of the agreement or the terms of the separation, that also violates Section 7. Again, Section 7 protects employees' rights to improve their terms and conditions of employment. This also means that employers are prohibited from denying employees the right to talk about their wages or their benefits or things like that. So any prohibitions on discussing salaries, wages are also unlawful under Section 7. This is an offshoot of that. I will say, frankly, we've known this for a long time. It's pretty clear under the law that this is probably unlawful. We've just been knowingly violating it for like the longest time. And this is being recorded, so I can't say I'm going to continue to knowingly violate it. But I will think about it. I think we just have to make some decisions as far as what we want to do or what the penalties are. These are business decisions. Certainly, we don't want to get crosswise with the NLRB. I don't really want to have to worry about it. I think it's an interesting decision, even from a legal perspective. But anyway, something to think about, and just gives you a sense of how aggressive this board is being. That is the hot off the press news that I have from this week. So you'll. If you want to get on our distribution list. We send out alerts and updates on employment developments. My team has sent me a draft of an alert on that this morning, which I'll be reviewing and will be going out probably later today. So if you want to get on that list, that could be your first one. And yeah, we'll kind of try to keep people posted as best we can on both, obviously, the labor relations board stuff, as well as all the kind of other things that happen throughout the year. I hope this year has fewer updates than last year did. It's hard. Every year I say, like, can you believe all they did last year? And then the next year is worse. So hopefully we don't continue to suffer, but.
Right. We're always waiting for the legislatures of the federal government to surprise us, right? They can out themselves.
Yeah. Like during 2020, when we all had enough going on, the Congress decided that like that was the year they were going to suddenly get their act together and pass like 7 employment laws. And we were like, that's a tax law. Would you like? We got enough to read and do.
Seriously.
Okay, so we've got just a couple of questions. Hi, Steve. It's nice to see you. We've got a question on the pay transparency. Can we provide a link to the full job description, or does it have to be in the ad? I would say a link is sufficient if it's an online application, or excuse me, an online posting, or something posted internally. If we've got an ad, I would at least try to provide a summary of the job description. I doubt any of us are advertising in newspapers too much, but like that's what I'm envisioning. I don't know why when I think of a job advertisement, but a link would probably be sufficient. I will say the state does not have a ton of resources to be policing this, so I wouldn't be overly concerned with like technical compliance as long as we have substantial good faith compliance, which is what I would say this is here. So until we see other guidance, I think that would be fine. The flip side to that is requirements relating to things like pay transparency are very easy for the public to police. So like we are aware of plaintiffs who they're kind of like armchair lawyers, like well, I just picture it this way. I don't know if this guy really does this, but like we have a plaintiff who just, he's a serial filer, and I just picture him on his couch, like looking for job postings that violate certain laws. And then he files a claim and he just gets like $500. He doesn't even care about litigating them. He's just like 500, I'll settle for $500. We're like, okay, because it's not worth fighting it. But like he makes a living by literally finding these violations. And then, getting settlements. And again, he can just do that from his couch. Maybe he has an office, but like, doesn't this sound like the type of guy who's just sitting on his couch? I mean, let's be honest. Right. So anyway, my point is anyone can be sitting from anywhere and file a claim when we have things that or claims related to things that we're posting to the public. So we just want to be very careful with that. Again, same thing. I think it'd be more than this would appear to me to be substantial compliance. I don't think you'd be at risk, but it is one of those things that we want to make sure we are paying attention to. We do review employee handbooks. It depends on your number. We usually do them on a flat fee basis, but it depends on how many states you're operating in and how many employees you have. But if you want to email me, we can talk about that.
I was looking at Jackie's question about companies that send notices regarding all the posters that we must purchase to ensure we're not in violation. I'm not exactly sure.
Yeah, Jackie, do you want to maybe just hop on? Is your microphone working?
She's there. There she is.
Can you hear me?
Yep.
Yeah. So specific company in mind, personal concept. They send those nice big laminated posters that they say every single poster you need for New York State. I mean, these companies, I'm guessing they're right on top of every state and blah, blah, blah. And, I've gone back and forth, feeling threatened, feeling scared that, oh, shoot, I probably don't remember every single thing I need to look up. So I should just purchase this because it's going to protect me from harm and danger. And you know, they can get expensive. And I was just wondering if you could talk about that and how we, are there other alternatives?
Yes, there are companies that provide the notices that you can pay for, and it theoretically would be great. Or I would think that we'd be able to rely on them, right? That's their whole existence. But I don't work closely with any of those companies to really be able to vouch for them. I do think, at least from the state level, again, and I can probably, let me just pull up, I can put in the chat the New York poster requirements that this is the website here. So I put in the chat, this is the website that has all of the New York State posters. And if the state came in and said, oh, you're missing this poster, and you said like, well, I have everyone that's on this, that applies to me, that's from this website, they're going to have a tough time telling you you're wrong. So from a state perspective, I would go with those. I don't know why I didn't do this, but I didn't Google federal posting requirements. So it may very well, there may be something similar, but this is where I would pull the New York State ones from. I think this is actually better than, one, it's free, so that's great. But two, if you say, oh, I paid this company, they're going to say, well, how does that company know? If you say I relied on this, that'll be a pretty defensible position. Again, that's at least from the state requirement. I think paying them for the posters is a little bit of a scam, but maybe that's just my own personal bias.
Yeah, you almost have to, if you buy, I know different employers have bought them and they look, and I mentioned that, it's hard without a list from the Fed, it's a little tricky, but you can almost, if you're buying one, look at the poster and then compare it with this list and just make sure all those posting requirements are in it. And then you feel a little bit better about it to make sure it's right.
Yeah.
I know that a few of our payroll companies also that you might use either provide them or can get you one at a fee. So if you're working with a company already, you may be able to access it through, I know Complete Payroll used to have them through their HR piece, their what do I want to say? Part of what they offer, and that may be a solution too if you're looking for one.
Yeah.
But yeah, they can range into the $40, $50, $60 or more range.
Yeah, I also threw a link to the new EEOC poster. There's a number of options on that. In that link, you can get it in any format. It could be electronic, it could be PDF, it could be printable, it can be readable, it can be this, it could be that. So there's a million in there. That's the new EEOC poster. But if you need others, or you want to kind of cross compare lists, we can do that as well.
All right. We can share that too.
And then finally, we've got the pay transparency requirement. That's 4 more employees. That's any employees, 4 more on payroll. I wish it were full-time equivalents, but.
So it's if you're paying 4 people, whether they're part-time, full-time.
Yeah, the statute just says employees, so.
Okay. Good.
Okay.
Do we have any other questions?
Yeah, lay them on me. You can feel free to unmute too. You don't have to use the chat.
We'll give people a second, or if you want to ask a question, you can also turn off your mic or turn on your microphone and just ask it live if you want to. We can do that, but we'll wait a minute here and see if anyone has anything to type.
Just wanted to know if you could also put your email in the chat. Would that be okay?
Great idea.
Thank you.
Yes.
It's the best question I heard. No disrespect to the others, but what is swing and a miss on my part?
All right. Well, it seems like, I don't know, everybody a chance. People can ask, I mean, right, now that you put your email up, they can get a hold of you with something that we might have missed or didn't want to ask in the chat or whichever. So, and we appreciate that. Thank you, Kim.
Welcome. Thanks for having me. It's always nice to join you guys.
Yeah, well, and we do. We appreciate you for taking the time and providing some really valuable information to our members and everyone that tuned in, and we'll make this available for anyone that might have missed it, because I know there's a few people that did miss it today. So if you're all right with that, we'll do that. And if anyone wants to contact you, they certainly know how now, and we'll put some of this information in some upcoming emails and things too, just to get that out there as well. So with that, again, just thank you, Kim. We appreciate your time and great information.
Thank you. See you all soon.
Thanks, Kim. Thanks, Scott.
Thank you. Have a good
Bye.
day.